Welcome back to our series on intellectual property. Part 12 is where we're going to talk about copyright infringement. And this is exciting stuff. This is what happens when things go wrong and we need to sue to protect our rights. What constitutes infringement? This is good stuff. But before we get into that, one more introduction of myself. My name is Jeff Keiser, and I'm a lawyer from the United States. I'm also a legal English educator, and I have been for 5 years now. I love how words work and how languages work, and I'm so happy to be able to share some of that with you. I hope you've enjoyed some of our discussions about intellectual property, and I've certainly enjoyed giving it to you. So thank you for paying attention, and thank you for spending some time with me. I've really enjoyed it. Copyright infringement is the unauthorized exercise by a third party of any of the exclusive rights of copyright holders, such as copying, is copyright infringement. There's no real test for how much copying is too much copying. It's kind of like high school. But we know that copying becomes actionable when the defendant had access to the original work and what is left is substantially similar to that work. That's a presumption in the law that when you have access and what's left is the same, it's copyright infringement. These infringement issues have varied over the years, but over the last 20 or 30 years, technology has really made things more difficult. Modern technology makes it relatively easy to copy a product or information, and many companies get their revenues from replicating what other companies have done. Copyright has been modernized, and they opened a new office in 2018 in the US to help coordinate with internet-based projects and modernizing the Copyright Office and the Library of Congress. You know, it's funny to think that 50 years ago, we couldn't simply email a document to each other. You know, a PDF wasn't a thing, let alone what's been going on in the music world or with Napster or BitTorrent or others that have made piracy a real issue. Think about with photography. The concept of derivative works when you are playing with Photoshop changes everything. So we can copy someone else's photograph and have a perfect reproduction. That's all new, and that's something that society is struggling with. It's just one of those things where the law is struggling to keep up with the technology. So when you cut and paste, or you take a screen grab, or you otherwise use other material, we always need to think about whether it's copyrighted. On this slide alone, this little camera image, it's absolutely copyrighted as part of the PowerPoint software package, but they have given a license to people that use it, or at least people that have paid to use it. Another entirely different problem when it comes to copyright infringement. The Berne Convention is an international treaty that governs copyright. It establishes minimum standards for copyright protection around the world. And it's a fairly large treaty with I believe about 100 countries signing on. The DMCA, or the Digital Millennium Copyright Act, is a new US law that tries to address copyright issues in the digital age. Even though by the time it was passed, it was already out of date. So it's still the law in effect, but it's impossible to stay on top of technology. One thing that we've seen a lot is, and is a part of the DMCA, is the idea of a takedown notice. On YouTube, for example, if you post a video with any kind of copyright material, usually a music in the background or something like that, you will likely receive a takedown notice from the copyright holder. And it's simply a cease and desist letter saying you need to take this down now or else we will sue. And so if you ever get a takedown notice, chances are good you're infringing on somebody's copyright and you'll need to take it down. Copyright infringement and international protection is very complex. It can be difficult to prove who owns the copyright. And as an outsider coming into a foreign country to try to protect your rights, sometimes courts aren't so happy to have that happen. We try to keep the rules as harmonized as possible, especially great organizations like the EU. But it's really next to impossible to do that. It really is. It's a real challenge for everyone, and that's why I think when we're talking about copyright infringement, we need to look to the future, not the past. And I certainly don't have all of the answers for this, but it's the kind of thing that I recommend we all pay a lot of attention to. Because as you know, it takes a second to email a song or a book or anything without the author getting paid or even recognition for it. Again, those are the reasons that we have intellectual property law in the first place. Now, moral rights, we've talked about them once before, and it's an interesting subject because it's not really a monetary damage. Moral rights can protect the author's right to be identified as the author. Even if it's in the public domain, I wouldn't recommend changing the name of the author to you. You wouldn't say, trying to think of a good public domain book, but let me think. What's really old? Shakespeare is all in the public domain. But I wouldn't say Romeo and Juliet by Jeff Keiser. That's where the moral rights might come in. Like I said, these vary from country to country greatly, and the US does not enforce them. So there would be nothing wrong with me publishing Romeo and Juliet by Jeff Keiser, even though I don't think very much that anyone would buy it. Here's one illustration of what I'm talking about here. And it was Napster. And this was back in the early 2000s. And it started off as a simple website that allowed people to share music files with each other. I could send you a song that I like, for example. Well, you can imagine that the record companies were not very happy about this, and they sued Napster for copyright infringement. Now, and they lost. They lost and went bankrupt, and I don't know if Napster is still a website that exists. It probably is somewhere. But you can no longer share music like that anymore. And that's all because of copyright and the protections that it affords the authors of works. All right, guys, we've got 2 more classes for you. Believe it or not, 2 more short videos, and I hope you enjoy them. The next one is on a very important subject when it comes to copyright law. That is fair use. Stay tuned, and I will tell you all about it.